Okay, guys, we're live now. So we're now live with our online attendees. For everybody online, you won't be able to see, but we have a group of people here in the room, our lovely attendees who've made the trek into our Sydney office. They are going to be asking questions throughout, but if you are online, then you can pop a question into the Q&A box that should be at the top of your screen or the bottom. I don't know where it is. Pop a question and we'll do our best to answer it. But welcome to everybody here and online. Welcome to the Hunt and Hunt lunchtime seminar and webinar, which is on the topic of, let me just move to my next slide. Sorry, I'm getting my first time doing online and in person, so please bear with me. Paul, help. There we go. The topic today, as you know, is Business Support Series, and this is in celebration of Small Business Month. For those who don't know me, I'm Sarah Capello, and I'm a partner in our commercial team. So a little bit about Hunt and Hunt very briefly. Most of you know us here, but we are a mid-sized firm. Our logo is Genuine People, Practical Solutions. So we focus on people, we focus on clients, and we really want to support our clients. And we believe we do that by listening first and understanding what the needs are to make sure we meet outcomes. So we've got a fantastic lineup of panelists today. Online people, they are all sitting to my right. They're eagerly anticipating, excited about joining us. As I said, I'm Sarah Capello and I'm the partner in the commercial team. I've got Tyrone Walker joining us from the IP team, Wendy Conceso, who's in our property team, and we've got Daryl Corsbrook, who's a special guest today, who's from next door. He's from Corsbrook Accountants, and we're very grateful that he's made the effort to come over and give us some very insightful information for small business owners. So SMEs, many of you know that SMEs make up a huge part of our economy. They are fantastic employers. They're much needed for revenue. They're fantastic. So SMEs are a really great part of the economy. What we usually find in terms of the makeup of SMEs is they're typically businesses around less than 20 employees and with turnover between 2 to 10 million. There's a lot of different definitions about what an SME is, but this is the kind of stats we've taken on in a general sense. What is really common amongst SMEs is that you have the owner is typically independently owned by one or a few people, and that owner is often the person that works within the business, so they're the manager. And that owner has to wear a lot of different hats and has to be across a lot of different skill sets in order to make the business run. And this is why we wanted to do a series like this, because we want to give information and be a resource to those business owners who are having to understand a lot of different aspects. I myself was an owner of a small business before the merger with Hunt and Hunt, so I really understand the kind of different tasks that you need to do to make your business succeed. So I get it from that perspective. And you know, where Hunt and Hunt, we work with SMEs often. They make up a huge part of our client base, and it's important to understand what their needs are. So the agenda today, I'm going to be covering off the employment and commercial issues. We've got Wendy, who's covering off leases and property, Tyrone covering off trademarks and intellectual property, and then Daryl's covering structuring and tax considerations. So the purpose of today is just to give you a really brief snapshot into some things to think about. So hopefully you walk away either thinking, great, I need to do this and here's the information of where to find that, or you're thinking, great, I'm on the right path and I've actually covered all these things as well. So we're hoping you get a really broad understanding of some certain things that are relevant to many small business owners. Again, any questions, pop them in the box. It's a great time for you to kind of get some free legal advice during this time. But diving right into employment and commercial consideration. So this is employment area is a bit of passion of mine. I've got my colleague Joey here with me who works often with small businesses. And we find with small businesses, obviously they don't have the same resources that a bigger organisation can have. So often the business owner is the HR manager, for example, and they have to deal with employee issues. And employees make up, a really massive part of a business. They're often the biggest asset of a business, and that's most of the things you're having to deal with on a day-to-day basis. So most employees, I have to be careful, we fall under the Fair Work Act. There are state-based systems, but for this discussion, we're just talking about the federal-based employees. Almost everyone here will be dealing with employees under the Fair Work Act. So there are minimum standards that you must be aware of, and they're called the National Employment Standards. And they're things like your right to annual leave, your notice periods, the right to take sick personal leave, and redundancy payments, for example. So there are minimum standards that everybody has to meet, no matter whether they're under an award or not. Then the next thing to be aware of is to have employees to be aware of the award for employees who are under an award. So not everyone falls under an award, and this is where a lot of confusion can lie. But if you do, then you have to make sure that the employment arrangement meets that award as a minimum condition. So awards are minimum standards. You can pay people in accordance with an award, that's completely fine. But if you want to then deviate from that, you have to make sure that you're paying or the conditions are better than what the award conditions are. That's one of the questions we get most often from our clients, particularly small businesses who don't have full HR departments doing award reconciliations. But it's a lot of big businesses who get in trouble with making sure that they're not complying with the award. And that's where you hear about those Fair Work claims, where you have those huge underpayment claims, and they get a very big slap on the wrist. So it's really important to make sure that you're aware of what they are. There is fantastic resources through the Fair Work website where you can actually go up. There's an award finder. Sometimes it can be confusing. If so, just give us a call and we can talk through it. Other legislation that it's good to know about, obviously work health and safety, a very big one. You have to make sure that you're providing a safe workplace for employees. There's a lot of changes that have come about in the past 18 months and is coming up in the future. And there's a little bit more of a focus on psychological claims. So there's obviously safety and physical obligations you have to meet, but there has been a kind of deviation a little bit more into making sure that things like stop bullying and harassment is kind of being minimised to make sure that people are healthy, both in a physical and a well-being sense as well. So a lot of the changes you'll see to the legislation is centred around that. And there are some guidelines that are coming out under the Sex Discrimination Act, which will they're already out, but they will be enforced from December. And this is putting a really strong positive obligation on employers to make sure that they're proactively taking steps to prevent sexual discrimination and harassment. So this is a really big one to be aware of. Joey and I put out a lot of resources on this, which you can access through our website, or you can reach out to us and we can send you those resources. But that's one that you must be across, because as a business owner, you have to take positive steps to eliminate some of the harm and the risks associated with your employees. Superannuation guarantee. Most people know about super. It's a given. It's been increasing. There's probably more Daryl's area than mine, but this is the one to be aware of. Workplace Surveillance Act. I popped that down there. I mean, there's a dozen other legislation that is relevant to businesses, but the Workplace Surveillance Act is one that's come up a little bit more often in the past couple of years. And this is because the workplace is moving these days to becoming a more flexible workplace. So we've had a change post-COVID to a lot of businesses offering some flexibility, and that's to allow people to work from home. And so in that, there's a lot of questions we're getting from business owners saying, what about productivity? How can I monitor my employees? What can I do to make sure production doesn't go down? The short answer to that is, in most instances, you can monitor your employees. You do have to give notice. So we often recommend that this is in the employment contract, but if it's not in there, then make sure you give written notice that you're actually monitoring their performance, or you're monitoring their emails, or you can even, that applies to cameras, for example, or any other software and systems you have that monitor their productivity. So notice is essential. Once you have that information, it's about what you can do with that, and then that's about managing the termination process. If you've given warnings and they're not producing as they should be, you can use that evidence you take from that monitoring to support the decision to terminate. And if they pursue an unfair dismissal case, then you use that evidence against that. There was a case in the media, I always forget the name, maybe Joe will remember, but there was a case in the media about this young lady who worked for an insurance company. Sorry, you were mid-bite. She worked for an insurance company, and she was sacked because they found that she wasn't productive at all. And how they discovered that, they monitored her keystrokes, and they found that throughout the day she was doing something like, I don't know, it was very low, like 50 keystrokes throughout the day. They could see that she was clocking on at like 10 a.m. and clocking off at 3. There were some days where they measured her doing, 40 minutes of work throughout the whole day. And it was repetitive. It was every single day. But they, invited her in for a meeting, said, what's going on? This is what we've been doing. And they ultimately terminated her. She took the very foolish decision to make an application for unfair dismissal, and she lost. But there's some of the things you can do as a business. Hopefully you don't get to that stage. I always recommend that you speak to your employees just to have a conversation. That's always the best approach. But if not, there are things you can do to make sure you can get things back on track. SME specific advantages. There's a lot of, on the one hand, you don't have the same resources like HR departments and payroll people and all that stuff, but you do have some benefits to being an SME, particularly under Fair Work. So the first one is the Small Business Fair Dismissal Code. So you have some exemptions in terms of dismissal. So a lot of people know that there's, a lot of people assume that there's rules like you have to have 3 meetings before you can actually sack someone. There's no specific rule about that. That's kind of just an assumption that's made to make sure that there's some procedural fairness, and often we recommend that. But for small businesses, it might not be practical to have 3 meetings with a support person, with a staff member who's not performing. It might be practical to have 1. So the Small Business Fair Dismissal Code actually says, okay, we understand in a small business you need to move quicker. There might not be the same opportunities that you can have to performance manage, and therefore you're giving some exemptions. The other thing that is really handy for a small business that it is greater minimum periods of employment to file an unfair dismissal case. So most people know about probation. Is that right? Probation periods, typically around 6 months. This kind of typically aligns with your minimum periods for unfair dismissal for small businesses, and that's defined as any business with less than 15 employees. So if you've got 15 or 16, it doesn't apply, but if you've got less than 15, then you can terminate an employee within the first 12 months and they can't bring an unfair dismissal claim. So that's really handy because it's a time you can get to know one another, and then you can terminate them if it's just not working out. That's a good enough reason. It's just not working out. You can't terminate them for prohibited reasons, as like something discriminatory, for example. But so if you're kind of borderline as to whether you're worried that there might be some other claim, then get advice. But if it's just because it's not working out, they're not performing, you can do it within the 12 months and you can't be sued for unfair dismissal. No redundancy payments. That's another really big one that people often aren't aware of. If you need to restructure, or you don't have the funds to keep paying people, you can make them redundant and you don't have to pay the redundancy payment. That's a big help to small businesses. You still have to pay the notice period, but just not the redundancy payment. You can give them notice and they can work out the notice. Often people pay in lieu. The casual conversion exemption is one too. So this is if you're employing casual people. There were rules that were put into place about 2 years ago, I believe, maybe even more, about making sure that casuals were given the right to be converted to full-time or part-time employees. That doesn't apply to small businesses for reasons that I'd mentioned before, that they have to be agile and giving them more flexibility. Any questions on those? No, let's keep going. Over any period of the year. At the time that the action's taken. Yeah, good question. So managing employees. So here is just a couple of recommendations to look for when you want to manage employees. So the first thing is, if we have questions like, can I make a employee come back into the office if they're working from home? Always, number one, check the employment agreement, see what that says, right? That's the number one thing to do, check the employment agreement, because often you forget what's in there. If you don't have one, don't stress, come to Joe and I, we'll get you one. But then if you also don't have one for this particular employee, you want to check the award, because the award would tell you what you have to do as a minimum standard. Next, you want to just look at what you want to do and get advice. Now, as I said, if you can't come to a lawyer for whatever reason, Fair Work is a fantastic resource. So you can either go to their website, they've got a really good hotline, they're a really good resource for businesses. Got a question, but I'll go for a sec. And the last one is, and this is often the answer for in the employment law space, is a reasonable lawful direction. So when you have an employee, the whole concept of an employee versus an independent contractor or a different, just a contractor, is that the element of control, right? So that's the kind of essence of the employment relationship, where you're paying them a remuneration, you're paying them a salary. In exchange, you have an element of control to a certain extent, right? And they're employed to perform a certain duty. You can issue a direction to them and they have to comply. And if they don't, you can terminate. But the test is whether it's reasonable and whether it's lawful, right? So the reasonableness will come down to what the terms of the relationship are. So for example, if you've employed someone to be a lawyer, but then I want them to go pick up my dry cleaning, it's probably not reasonable to ask them to do that. It's lawful. There's nothing lawfully stopping them from doing that, but it's probably not reasonable because that's not their skill set. So there's the two tests, reasonable and lawful. And if you meet those two tests, then you issue the direction. I often recommend that it's in writing. It can be an email, that's fine. And if they don't comply with that, then you can essentially terminate, give them a warning, but that's what it comes down to. So coming back to the example of, can I get the employees back into my office? That's the question we have all the time. Now, one, you've looked at the agreement, doesn't say anything about it. That's fine. You've looked at the award. It might say, you have to consult if they're not under a flexible working arrangement. And if there's nothing prohibiting you under those two instruments from doing that, the next thing is, okay, right, issue a reasonable lawful direction. All right, I think I'm taking up too much time, aren't I? All right, so going quickly to commercial considerations, right? So I'm the head of the commercial team, but I don't do specifically a lot of commercial work. We've got the wonderful Richard, who's in the room today, who's our commercial lawyer, and we've got Tanya in our team as well. So I just wanted to touch upon a couple of points in this. So commercial, you want to make sure you always know and understand the terms of any agreement that you're entering into with anyone that you're dealing with. So suppliers, distributors, manufacturers. Make sure you read the contract. I mean, it sounds really basic, but oh my gosh, people don't do that. They don't read it. You don't always need to get advice, but we recommend that you do. But just use common sense. Read it and understand what it says before you sign it. If you're entering into a large transaction that's going to have a huge impact upon your business, get the advice so you understand the consequences, because people often come to us after a deal's done and say, what can I do? And they're stuck in this agreement. So the type of contracts that you want to think about, it's always best to have them in writing. I know in small businesses not as common, but you need to understand what the terms are. So think about things like, what happens if there's a dispute? What are my payment terms? Or what happens if I don't pay on time, if I can't afford to pay on time? What do they have to do in terms of what they're delivering? What if there's an issue with quality? So how do I get out of this? That's the number one thing you should always ask. How can you get out of an agreement if you want to? And make sure you understand what the ramifications are for that, so that you can move on if need be. So things like your client and customer contracts, that's really important because they're your engagement terms. If you're a professional service provider, you want to make sure you clearly set them out in your engagement document. Otherwise, if you're, for example, in retail, you want to look at your terms and conditions, your sales contracts, your terms of use, which are on your website, which I think Tyrone's touching upon, and then obviously your employment contracts and contractor agreements. So again, put it in writing. SME specific advantages. So I want to briefly touch upon the unfair contract terms. So Rich has been really busy working on this at the moment because there's big changes coming from the 9th of November. We've got some resources online. Richard wrote an article about the upcoming changes. Essentially what it comes down to is that if you're a small business, firstly, the definition of small business is expanding from 9 November to less than 20 employees to less than 100 employees. And less than 10 million turnover. But if you've entered into a standard form contract and there's terms in there that are unfair, then there's a possibility that those terms can be deemed to be void. So you want to be aware that if you haven't followed my recommendation in the earlier slide and got the advice and read the terms and all that, you might have some relief under the unfair contract term provisions to try and help some of those terms be deemed void. As against that, you need to be acutely aware of potential penalties and restrictions that are in place if your contracts have unfair terms, because from 9 November, there's pretty strict penalty provisions. But if you've got questions about that, Richard's in the room, he's at the back there, sorry, Richard, go and ask him after this session, he can tell you a little bit more. So I'm just going to answer a really quick question and then I'm going to pass it to Tyrone. He said, will you be talking about annualised salary agreements? I can't get an answer as to if casual employee agreements can have an annualised salary agreement, particularly if they have been offered permanent. Okay, I'm going to take that offline later on because it's very specific. So whoever sent that through, I'll answer that because we just don't have enough time today. So I'll get in touch with you after the event. If you want to just shoot me an email, I can answer that then. All right, so that's all from me, and I'll be passing over to Tyrone, who's talking about trademarks.
Good afternoon, everyone. So I've done mine a little bit differently. I've kind of put 12 questions that summarizes intellectual property, common questions that a small business will kind of ask. So the first question, is, what is intellectual property? Well, IP for short is basically anything that's uniquely created. So businesses all create something unique or have something unique. And you might think, well, I just have a simple accounting business, or a simple IT business. That's not unique. Well, if you actually think of your name, a good example, Motive IT, they've got a unique name for their IT business, and they can actually protect that. So intellectual property protects anything that's unique, anything from a business name to a brand, to an invention, to a product, to even a service, can be protected through IP. Question, do I need IP protection for my business? Well, it depends on the business, but generally, yes. The first thing that you always need to do is actually protect your business name. And I'll give a few examples later where other businesses actually haven't filed a trademark and they've actually been their business name's been copied, and a business name has been registered, which is identical to their business name or their name. How do I identify and protect my intellectual property? Well, this is where we come in. We'll have a look at your business, have a consult with you, and have a chat about your business. Get to understand your business, and we can see if there is anything to be protected. Generally, there is, and we can help along those steps. We don't charge for that initial consult and actually assessing your business and having a look at what can actually be protected. Sorry. Which type of IP protection is right for my business? Once again, we'll have a look at your products, we'll have a look at your services, see if there's anything uniquely created. When it comes to inventions, I'm just going to touch on this topic. If you're an engineering business or anything chemical, you might be producing or inventing something that might be unique. Before you actually launch that to the public, it's quite important that you contact us and we have a look if we can protect it. There's a thing in our law that if you actually launch your invention and show members of the public or your clients this invention or this product that you've created, you actually could lose that protection. So it's quite important that you contact us beforehand. So what rights do I have as an owner once I have that IP? Well, basically, you will get a registered right depending on the protection, and you can stop others from copying your intellectual property. And when I say you've got rights for that intellectual property, the one question was, how do I prevent employees from sharing my IP? Well, number one, you've got to protect your IP. Once you've registered that IP, if you protected your invention, your product, your name, you can actually include certain intellectual property clauses in your employment agreements, and that's obviously where Joey and Sarah come in. And if you licensing, you can license, sorry, if you're contracting with another party, you can actually license that IP right out. So in those agreements with a third party, you'll include intellectual property provisions and clauses, and you actually state that you're the owner of that product, that service, and the unique concept around that, and you'll license in that right. What steps can I take to enforce my IP rights? Well, that's when we come in again. If you have an issue where somebody has copied, say your brand, or copied your product, or copied something unique that you're doing, you can contact our offices. We'll have a look at whether that thing is actually protectable, or have you protected, and can you stop others from actually copying whatever you've done or whatever you've uniquely created. What are the costs associated with IP protection? Funny enough, small businesses think IP protection is actually a very costly exercise. In the bigger scheme of things, it's not. So to give you an understanding, a trademark can be filed for close to $1,000, and that will give you protection for 10 years with that brand, or you'll protect that brand name for 10 years, and it'll only be renewed every 10 years. So you're going to only incur approximately $1,000 cost every 10 years, which in the biggest scheme of things is a very small cost for your business. Can I share my IP and still protect it? Once again, we go back to what I've said. As long as you protect it, or as long as you protected that IP, it's always a good idea to obviously have a contract in place with a third party, have the necessary provisions and clauses in there, which state that you are the owner of that IP, and obviously you're licensing that right to them. You'll have a license portion of that agreement, or a separate license agreement, and you'll stipulate in there the term of the license, how long. You can even license it at a cost. There's even businesses today that will franchise the name out of their business or the concept around their business, and it certainly happens in the restaurant industry. A question that I got before the webinar was, how can a small business protect their design from being copied? Well, number one, contact us before when you're creating that design, or if you have created a design, let's have a look at registering the design. If we can register that design, obviously you can stop others from copying it because you'll have a registered protection over that design. Another question was, what rights do we have to continue a business after 25 years using an American trademark registered in Australia? It's quite a complex question and I can't answer it simply in about a minute, but it depends on various factors. Number one, does this American company have a trademark in Australia? Number two, do you have a trademark in Australia? Number three, when you created the brand, were you aware of the American business? Have you been trading concurrently in Australia? These are all factors that can affect the answer, and I recommend you pop me an email, send me an email, and I can probably assist you. You've obviously received a letter of demand from the American business stating that you must stop using their trademark or the brand, and that's what happens when you have a registered trademark. You can enforce your rights and stop others from using it. Trademarks are territorial, so basically if you register a trademark in Australia, that doesn't mean that you can stop somebody else from using your trademark in New Zealand. You actually have to go register your trademark or your brand in New Zealand. You don't have to actually be trading in another country to register the trademark there. So often companies will extend their IP protection to other territories where they foresee them going into other markets. So they already go and spend the cost, the money, and file the trademark and get it registered in those countries, or a patent to protect an invention. Another question I get from small businesses, I've been trading for 10 years with this brand or with this product. Why do I need IP protection now? I'll give a few good examples. I've had lots of small businesses come to me and say, I've done a Google search, or a client has done a Google search, and all of a sudden in my Google advertising, or one of the links that pops up is my trademark. It's being used by a competitor. In the actual Google search results. Now, if you have a trademark, generally speaking, you can stop others from actually utilizing your trademark in a fraudulent or in a copied manner. So often in Google search results, or competitors will use the competitor's trademark or their name, to rank higher in the Google search results, to obviously get more hits, to get more business. So that's why you would register a trademark. Another example, which I'll show in the next slide, is actually fraudulent business names. So I've assisted a lot of companies around the world where they've got a trademark or they've traded with a business, and a competitor or a third party has gone and registered a very similar or the same business name. And this happens on a daily basis, and I'll show you in the next slide. Another example of why you would register a trademark or a business name, or a trademark for your business name, is social media. A good example, we had a real estate company the other day contact us, and a Facebook page has popped up with the exact name for that area. And they said, well, Tyron, what can I do now? Well, number one, we can obviously lodge a complaint with the social media companies such as Facebook or Instagram. But generally speaking, you need a trademark to lodge the complaint and be successful, to remove that Facebook page. And like I say, the little cost that it is to register the trademark, will assist in future hand with all these kind of scenarios. Another one at the bottom there, so I'll just chat about the slide quickly, is Amazon Books and Madonna. A good example is internet website addresses, so your www.madonna.com. Now, Madonna didn't actually own the website. Somebody else had registered the website fraudulently. So she had to utilize her trademark and her trademark rights to get that website back. So trademarks are really important, even for small businesses now, because if you've got a good product or you've got a good service, others are going to copy you. It's happened for the last few hundred years, where a good product or good service has been invented, created, and you offer that good service, it's going to be copied. Your competitor is going to look at it and go, I like it, I can do it better, but I'm going to rip you off. So that's why you're going to use a trademark. Good example here, quickly, Instagram pages. You can see somebody's ripped off Nando's and registered a very similar Instagram page. They're probably trading with a business, Chicken Nando's, on the corner somewhere. And I've assisted restaurants just like Nando's, funny enough, a South African brand where I was originally from, in stopping others from popping up with a chicken takeaway restaurant. Another example is Gap Clothing, also a client that I've previously assisted, and they will have companies and businesses pop up and obviously rip off and copy their brand all over the show, and that trademark is what assists them from stopping it. Going back to the fraudulent business names, here's a few good examples that I pulled off quickly yesterday. These are Australian businesses that have been registered. Ruin Tesla, Macca's Catering, BMW Mobile Workshop. Or you might say to me, but Taran, that's, why can't you register a business name called BMW Mobile Workshop? Well, the problem is you're utilizing the BMW trademark. Now, there might be that connection or association that you're an authorized service provider to BMW or workshop of a service provider to BMW, which is not the case. Porsche Build, Samsung Fridge Repairs, Hugo and the Boss, Nelson Mandela has even been registered as a business name. Another one was Barack Obama, that's not listed there. Gucci Poochie, Pepsi Lawnmowers. Now, Pepsi, for example, could probably go and stop this company from utilizing this business name and request them to amend or obviously close the business down. A few quick interesting cases. I'm just going to briefly say in one line because I know I'm taking too much time. Hungry Jack's, Burger King. Sarah had a good point yesterday to me. She goes, but Taran, these are not small businesses. Well, funny enough, when Burger King wanted to come to Australia, and some of you might know this already, this trademark case, the Burger King trademark wasn't available. There was a small business that had the trademark. So they couldn't actually start trading as Burger King in Australia. They had to rename the brand. And it was the first territory outside of the US that they had to do this. And they branded it Hungry Jack's. 10 years goes by after they're in Australia and trading and obviously successful under the Hungry Jack's brand. Funny enough, that Burger King restaurant closed down and their trademark lapsed. So Burger King US company quickly registered the trademark. Now they had to decide, well, do we now continue trading as Hungry Jack's or do we now adopt the new brand name or the original brand name, Burger King? And they decided to continue to utilize Hungry Jack's because they thought that, well, that we've created enough brand equity in that brand and we're going to continue. Obviously, Burger King, they will still use Burger King in a couple of places in Australia to make sure that there is use of the brand. So they don't lose the trademark, because you can lose a trademark if you don't make use of it. Quickly chat about the Sidewinder Better Beer. I don't know if anyone's had the Better Beer. It's a pretty good beer. Interesting thing about this case deals with packaging. So another aspect of IP is product packaging. And can you actually protect the product packaging? Well, in simple, yes, you can. And you can stop others from copying your product packaging. But there's obviously a few asterisks to that. In this case, Sidewinder sued Better Beer. They actually lost. They thought that the packaging was misleading, consumers would be confused. And funny enough, they were launched both at a similar time. So there was not a lot of reputation and goodwill that had been built up with the brand. They didn't register a trademark for the actual product packaging. They didn't have other aspects of protection. And I'm briefly speaking over about this product. But literally, Sidewinder had to rely upon their reputation and goodwill to stop Better Beer from utilizing that similar packaging, and they hadn't built up enough brand reputation in that can. The cartons above the coconut, I think it's coconut water. Also, another case, funny enough, the court looked at the industry and looked and saw that there was a number of product providers that are all providing a similar product packaging. So they lost the case there too. When it comes to product packaging, a good example is Coca-Cola. Coca-Cola will protect the actual Coke bottle. They'll file a trademark for that. Wine labels around the world will actually file a trademark for their wine label. And we've done that for a number of our wine clients. We actually file the label because that's that unique identifier. That's what makes you walk into a store and actually pick up that bottle. So you might think, well, I actually don't have anything unique in my product. Well, your label is the unique part. Quickly, Henley Arch, Henley Constructions, the trademark case, both in the construction industry and the one lost the trademark battle. You might think, well, Henley is quite a common name to be utilized. Well, in certain industries, and depending on how long you've used it, you can actually build up enough trademark rights and brand equity in a brand, even a common surname like Henley, and stop others from using it. Katy Perry, good case. Katy Perry, the Australian fashion designer, small business, stopped the musician from utilizing her trademark in Australia and was awarded damages. She's Katy Perry, the fashion designer, the Australian, has actually got registered trademarks and was able to stop the musician from filing trademarks and getting her trademarks registered in Australia. There we go. Crammed everything in. Thank you very much.
Okay, so my name's Wendy Concesio, but everyone gets it wrong, so it's all good. I'm a special counsel in the property team. So today I'm going to discuss leases. So for a small business, obviously your tenure is your lease, and that's the most important thing, to have your premises and the lease in place. So I'll talk about rent reviews, exercise of option, break clauses, and make good. So they're four of the most litigious parts of the lease. So there are four types of reviews in a lease. So the first one is a fixed increase. It's either a fixed amount or a percentage. The second one is a CPI. The third is a market review, and the fourth is a combination of two, which would be a CPI and 3%. Now, in a retail lease, you can't have a combination, so you have to have only one method of rent increase. Anything in a lease that provides, in a retail lease that provides for two different rent reviews is void. So the next thing is the ratchet clause. So I'm not sure if anyone knows what a ratchet clause is. So if you have a market review, now market reviews take place at the exercise of an option and sometimes in the middle of a long lease. So if you have a 10-year lease, sometimes it's in the middle at a 5-year point. The rent will be reviewed to market. So a ratchet clause provides that if the market falls at the time of the review, the rent can't fall below what was payable just previous to the actual review. Now, again, in a retail lease, you can't have a ratchet clause. So in a retail lease, if the market drops, then your rent or your retail rent will drop as well. So then next one is, when will the rent reviews take place? So normally it's on the anniversary of a commencing date. The lease will actually specify what date that the rent reviews will take place. And so your lease will have all the information on the anniversaries, and it will have the type of rent review that will take place at that specific time. So how's the market rent determined? So normally the landlord will give the tenant a notice of what he believes the market to be. Now, in commercial leases, normally you have to exercise your option before you're going to know what the market review is. So you will take a chance. Once you exercise an option, you can't back out of that option, even if you don't sign the lease. So if you exercise an option before you know what the market review is, and it is, extraordinary, the increase is extraordinary, then you are locked into that lease. You'll have to then there'll be regimes in the lease as to what you can do with respect to that rent increase. So a tenant, this doesn't apply to retail. So a tenant under a retail lease, they can ask for the market rent review to be taken place at least 6 months before, between 6 and 3 months before the end date. So if the tenant doesn't agree with the landlord's determination of the rent, the parties can go to an independent valuer, and they'll obtain valuations, and then they can discuss. And if they don't come to a resolution, then they can take it to the president of the Law Society, who will then determine what the rent review will be. There are provisions in leases which say that the rent reviews need to take place by a certain point. Sometimes there are not. So a landlord can skip a rent review, skip it for 3 years, and then come back and ask for all that rent once he finally determines what the rent will be. So you want to make sure that in your leases you have a time limit in which the landlord has to do that review, so that you're not caught down the road in 3 years' time when you've got 3 years of backdated rent to pay. So that's that. Does anyone have any questions on rent reviews? No? It's not as fun as trademarks, but anyway. So the exercise of the option. So generally an option to renew a commercial lease will be drafted in a form of an irrevocable offer. So like I said, once you exercise that option, you can't pull out of it, even if you don't sign the lease. So once you exercise, that's what I said, you can't get out of it. The formal requirements for options to renew are, they must be in writing. Now that's section 54 of the Conveyancing Act. And secondly, there must be sufficient certainty regarding the essential terms of the option to renew. Those essential terms include the parties to be bound, the premises, the duration of the option term, and the rent. So the main preconditions to an option to renew are exercising the option on time and the compliance with the terms of the lease. So the length of the exercise period will depend on the type of lease. So normally it's not more than 6 to 9 months and not less than 3 to 6 months before the end of the lease term. So if a tenant fails to exercise their option within that time period, they can't exercise, they've lost the lease. So it's up to the landlord whether they will grant the lease, but they don't have to. The other precondition is compliance with the terms of the lease. So generally, if the lease will be drafted to the effect that the tenant will only be entitled to the renewed lease if the tenant has punctually paid the rent and observed all of the terms of the lease, either throughout the term or up to the date of exercise of the option, and there's no subsisting breach of any lease terms either at the date of serving of the notice of exercise or at the date of serving the notice of exercise and at the date of expiry of the current lease. So again, if you're in breach and you do exercise your option in time, the landlord does not have to give you that exercise of option. They don't have to give you the new lease, and then again, you've lost your lease. So there is some statutory relief, but it's very limited and it's by court order only, and it can be quite expensive. So the key takeaway should be that strict compliance with the terms of exercise of the lease is required. So the next topic is breaking a lease. So this is very common and comes up all the time, and we get asked, every second day, can I break a lease? Generally, no, without penalty. There are some exceptions. So one of them is the failure in a retail lease. So if the landlord fails to give you a disclosure statement, so they need to give you a disclosure statement 7 days before you enter into the lease. So if they don't give you the disclosure statement, or this disclosure statement is misleading or has any false information, then the tenant at that time, they can terminate the lease, but only within the first 6 months. So after the 6 months has expired, you're locked in again, so you can't terminate. So sometimes commercial leases, they have break clauses and they're agreed upfront. So if that's agreed and drafted into the lease, then you can break the lease in that situation, but otherwise, generally you can't. Some landlords, they include a demolition clause or refurbishment clause. So if that's in there, then the landlord can terminate the lease. So the tenant, when they're negotiating the lease, they should consider the tenure of their lease. So if you've got a 3 by 5 year option, and you want to make sure that you have at least 10 years of that business. So you would say that you would draft the lease that demolition clause can only take place in the third term of that lease. So for the first 10 years, the landlord can't exercise their rights to demolish. They can only do it on the third term, so that you protect your tenure for the least 10 years. The Retail Leases Act provides that if a rental lease allows a landlord to break the lease on the grounds of demolition, the lease is taken to include the following provisions, even if it's not specified in the lease. The lease cannot be terminated unless and until the landlord has provided the tenant with details of a genuine proposal for the demolition to occur within a reasonable practical time after the lease is to be terminated. The demolition requires vacant possession of the premises, and the landlord must give the tenant at least 6 months notice. And for leases of 12 months or less, they've only got to give 3 months notice. So then you ask, what's a genuine proposal? So there needs to be sufficient details, but not necessarily every detail of the proposed demolition. The exact date does not need to be specified, but demolition must take place within a reasonable practicable time after the time period. And the commercial motivation of the landlord for demolition is irrelevant in determining whether the proposal is genuine. So compensation for commercial tenancies, there's no compensation. For retail, unless it's actually specified in the lease. So for retail tenants, if the landlord serves you with a demolition notice and they don't follow through with the demolition, then you can claim compensation under the Retail Leases Act. But the landlord can say that he genuinely believed that he was going to do the development or the demolition, and for other factors outside his control, he wasn't able to do it. So in that circumstance, he doesn't need to pay compensation. So there are other options to break clauses. So if you don't have the ability to break a lease, you could ask the landlord whether you can surrender the lease. But that is up to the landlord to decide whether he'll give you that surrender. And it normally a payment is required from the tenant. No stamp duty is payable on that, but if the landlord asks the tenant for a surrender, the landlord needs to pay stamp duty on the amount of consideration that is being paid for that surrender. You can assign the lease. So the lease will have provisions that will dictate who you can assign that lease to. The Retail Leases Act sets out the grounds in which consent to an assignment may be withheld. Otherwise, in a retail lease, the landlord has to give or consent to the assignment. So in a retail lease, the lessor is entitled to withhold consent in the following circumstances. If the proposed assignee proposes to change the use in which the shop is put, so if it was a clothing store, now they want to make it a butcher, the landlord can refuse the consent. The proposed assignee has financial resources or retailing skills that are inferior to those of the proposed assignor. The lessee has not complied with section 41, which is the procedure. So the assignor needs to give the assignee, so the incoming tenant, an assignor's disclosure statement. If they haven't done that, then the landlord can refuse consent. And in circumstances set out in section 80E of the Conveyancing Act, but that relates to the international airport and the retail spaces in the international airport. So that's very limited. So the timing of the consent in retail leases. So the lessor has 28 days in which to respond to a request for consent. If he can refuse, obviously, during that time. If he does nothing and doesn't respond to the notice, then he's deemed to have consented after 28 days. So that's crucial that you as a landlord, that you make sure you comply with the time. Another thing you could do is subletting the premises. So you can enter into the sublease, but if you enter into a sublease, as the tenant, you are still responsible to the landlord. So you're sitting under, so the sublease is sitting under your lease. So if the subtenant doesn't pay, then obviously you still need to pay to the landlord the rent. So you're still on the hook. So if you assign and you get a release from the landlord, or if you surrender the lease, then you're off the hook. But in a sublease, you're still responsible to the head landlord. So the other issue that comes about most days is make good, and what you think is the make good provisions in your lease. So the Retail Leases Act provides that a provision in a retail lease which requires the tenant to refurbish or refit a shop is void unless it gives details of the nature, extent and timing of the required refurbishment or refitting. So generally at the end of a lease, the tenant will be required to remove its property, yield up the premises in the state and condition required under the lease, leave the premises clean and tidy. If required, redecorate the premises. The redecorate will be painting, polishing, new carpet, new ceilings, anything that's been worn or damaged by the tenant, and make good any damage that they've made when they're removing their fit out from the premises. The extent of the make good requirements will often depend on the nature of the premises and the landlord's requirements, but it will be dictated in the lease. So some make good provisions are limited and only require the removal of detachable items such as desks, chairs and property and tenant has attached to the premises, such as partitions and shelving. And in other circumstances, the premises may be required to return the condition to what it was at the commencement of the lease. So in that regard, you should obtain or prepare a condition report. So you can prepare a condition report with the landlord. You don't need an independent person. Each party will prepare it, take photos, each party will sign it. And so you have a record for down the line as to what the condition was, because most often than not, no one remembers what the condition was at the commencement of the lease. And then you're going to get into an argument where the landlord wants you to do more than what was previously, in the premises. So, and it doesn't, if you do it yourselves, it doesn't cost anything. Some leases require a third party, an independent person to come in. And I had this one yesterday where a third party has to come in and prepare that condition report so that, it's independent and everyone knows where they're at. So another type of make good is returning the premises to base building standards. So that's the most excessive make good. So these require the premises to return to the state that they were in when they were first constructed. So you pretty much have to strip out the whole premises. So they really apply to industrial warehousing premises. Make good obligations can often be expensive, and it's important to be clear from the start of the lease what your obligations are. And also it is really important if you've got a further term. So the leases are drafted that on the date of termination, you need to make good. The date of termination is the end of the first lease. So if a landlord wanted to enforce the make good and you had 2 5-year options, they could make you make good at the end of that 5 year and then at the end of the next 5 years. So it's really critical that you negotiate and the lease is drafted that if the tenant remains in occupation of the premises, that they don't make good at the end of the first lease if they exercise. Now, if they move out, then that's fine, they'll make good then. But you make sure that if you're going to stay in the property, that you don't need to make good until you actually vacate the property. So that's pretty much everything that's on property, not as exciting as the trademark. Does anyone have any questions? No? Okay. So Daryl's up now. Thank you.
Okay. My session is on 2 issues. One is on business structures, and the other session is on the on the refinancing issues. Can somebody help me? Yeah. This. That one. Yeah. Beautiful. You can see I'm very computer literate. Like not at all. When you're looking at a business structure, and often clients come in and they come into the office and they say, what sort of structure do I have? What sort of structure do I need? And how much does it cost? They're the main questions that are asked. Well, in terms of the suitability of the business structure, that's usually not asked at all. And sometimes the business structure they want is not really business structure that we end up by giving them because we've got other things that we need to talk about. And they are things like what are your tax obligations in the business structure? In our audience today, we've got an eminent insolvency expert, Michael Jones, and he will no doubt be able to tell a lot of stories about tax obligations and the fact that you don't even think about those obligations when you start. But at the moment, they certainly are very high. So whatever business structure you want really comes down to what are the needs and what are the outcomes of that particular type of business structure and how you want that business structure to come out. I'll give you a quick checklist, and this is only a really minor checklist, but I'll give you one. Ownership. If you're self-employed, you might start off with a business structure to say, I want 100% own that business structure. And that's well and good, but later on, that might not be the case. So you might want to share an outcome. If you want to share an outcome of the business structure, it might be better for you to set up with a joint venture or a partnership. It depends on what your obligations are and whether or not you're allowed to set up. Another issue is equity sharing. Company is very useful because it's issued share capital. It's very easy to issue some more share capital. It's very cost effective and it's got some other benefits as well, and that's the liability issue. You're protected by and large under a company basis, but there are some exceptions to that, particularly the Australian Taxation Office and particularly with directors' penalty notices, and particularly with superannuation guarantee payments that haven't been made. There are opportunities for the ATO to look through the corporate veil and to attack you as a director, so that's very important. Professional requirements. We've got a lot of barristers as clients. They would like to incorporate, they can't, they complain every time I see them that they need to incorporate, they're not allowed to, they still complain. They have got extreme adverse attitude to paying any tax whatsoever, but that's another story altogether. Doctors are much the same and dentists are much the same as well as from a professional. And there's a whole stack of hybrid entities as well, which are available. Now let's look at the issue of taxation. When you're setting up a company, you're looking at major considerations are capital gains tax later on. Are there opportunities to have capital gains tax concessions available in that entity that you're setting up? It's very important that you get tax advice at the beginning of that. There are stamp duty considerations. And another consideration, which is not very often thought about, because people come in and they're very excited about setting up a business, but what happens when you want to dismantle a business? That is not to say sell equity of the business, but get rid of the business. And that in itself is quite an interesting strategy. can create a lot of issues which need to be workshopped when you're starting off, not later on. Okay, the next is the age of the structure. Company structures are in perpetuity. In other words, they keep on going and going and going, and they can be handed down. You can just transfer the shares in the company. A trust is not as such. Most trustees are the old 99-year trustees, but trust deeds aren't necessarily in perpetuity. You need legal advice. Our good friends here from Hunt & Hunt can give that advice. That advice is necessary up front when you set up a trust structure. Not so much a company, but certainly a trust structure and certainly a partnership, because there's obligations from a tax point of view which are very important and they must be considered up front. And then finally, everyone normally when they're looking at something says, I want to, how much does this cost? And that's a relevant question. If you're a small business and you're putting together a cash flow budget to start off your business and you're sensible to do so, you need to cost professional advisors, you need to cost setup costs for that business, and you also need to cost the ongoing maintenance costs, VAS costs, bookkeeping costs, the other costs that are necessary to run that business, and they are necessary to be financed as you start up a business. The next issue is business growth. I think we've got to change, isn't it?
That's all right.
Okay. Okay, let's go back. There's finance issues. Yeah, this side I want to look at. Finance issues are very interesting because finance issues, certain banks, and I'm not going to say that they are the big four, but they are the big four banks, don't like lending to trusts. Many times we've had a situation where they've knocked back lending to a particular trust, or they are slow and tardy about lending to trusts. And certainly, if you set up a discretionary trust or even a fixed unit trust, the bank shies away and says, what securities do we have? Do we have fixed property securities outside trust? Do we really have to lend to a trust at all? Do we really have to think about lending to a trust? And if we are going to think about lending to a trust, how long is it going to take? And when they start that question, we're talking months, and it has to go to a special section, etc. So sometimes it might be worthwhile to override consideration of using a trust, go to a company structure, for example, because it's just simply an easier method for the banks to deal with. That's not to say that banks can dictate, but the reality of the situation is if you need them, they've got a lot of power. Another issue in setting up a business is the guarantees. Every business needs some cash flow funding. It needs some capital, working capital to start off with. It might need to purchase, by hire purchase. It might need plant, fixtures, fittings. It might need office fit out. So there's a question of who actually owns that fit out. How's it financed? Do you go into a finance company for those fit outs? What deals are available? And there is a number of issues in relation to that. But probably the most important issue, and again I defer to Hunt & Hunt, is the guarantee. No bank will walk away from a deal without having some sort of fixed security. And fixed security could be usually, they love securing over your own house. They love first registered mortgage over your own house or a second registered mortgage. And that means that there's an issue of liability. That means that it's not a standalone business because it's a drag along business. I call it a drag along business because it's dragging you along into the funding arrangements, and that might not be suitable. But you've got to think about that to start off with. And if you do get dragged into those guarantees, how can you lift those guarantees in 1 or 2 years? Can you go back to the bank? And believe it or not, you can go back to a bank and say, I don't want to continue on with that guarantee because I have other arrangements and business has been successful and I don't need to provide that additional level of security. Without being rude to banks, they won't come and tell you that you can lift those guarantees. So consequently, you need a yearly checkup, like a dental check, to see what obligations your business has and to see who's giving those guarantees. Business growth. There are considerations when you're looking at a business growth. And those considerations range from taking on equity partners, as I said earlier, a succession plan for a business, a wind-up plan for a business. I see now that there's businesses that have been operating for 60 years or so, 50, 60 years, and they're going into liquidation. So obviously they didn't plan, or if they didn't plan, or if they did plan, they've reached a point in time where they need to assess what they want to do with the business and how they go forward with that business, and what are the best alternatives. That's another issue, which is to deal with insolvency issues. You don't want to start a business thinking that, but again, if you're forewarned and prepared, and you look at the opportunities and some of the ways that you can move forward the business, it's worthwhile to get professional advice on that. We've already talked about funding liability issues. We've talked about business needs to present its financial statements. It's not slow to say that tax compliance is absolutely 100% on the mark across Australia, whether it's BAS, whether it's bookkeeping, whether it's financial statements, whether it's statements for your superannuation fund. There's a whole plethora of statements, single touch payroll, etc. The Australian Taxation Office has got the largest computer in Australia in Canberra. Everyone knows that. And that large computer just sucks out a vast amount of information. And you can either be on top of it or behind it. And if you're behind it, it doesn't take much to run up debts that need to be paid. And specifically, those debts are not example for sheltered, like in the old days, they were sheltered in a company and you can walk away. That's not possible at all. You've got to look at the sorts of debts that the ATO are chasing and to see what the outcomes of those debts are. And before you do that, obviously you don't want to get to that situation. What you want to get to a situation is that you've got a cash flow budget, you properly set up the business, you properly provide for various outcomes that are necessary in the business, and also for contingencies, because even the best run businesses can have stormy weather, and how you plan is whether or not you can sail out of those difficult issues. Okay, I think a little bit more on financing. A little bit more looking at registrations. That last page is looking at registrations. And this comes back down to what is necessary with setting up a company or setting up any business. You've got to look at a corporation of a company. You've got to look at the corporate compliance issues. You've got to look at ABN registration, GST registration, PAYG registration, FBT registration. If it sounds like it's a nightmare, it is in some ways. So consequently, you need a trusted advisor who can steer you through this. And you need a number of advisors, not just an advisor, but you need a legal advisor on the issues that have been covered today in a small business. A small business doesn't mean you've got small problems. It just means that you've got less resources to tackle those problems. The problems are still the same, and they've got to be catered for, and they've got to be costed. That's my overall issues that I've gone through today. Are there any questions? No? Okay.
Yeah, if you've got any questions online, you might not be, on there. You might not be out of the woods just yet. Let me see. No, that was just a admin question. Okay, all right. So thank you, Daryl. That was great. I learned a lot too. Here are the course book details. If you want to get in touch with Daryl or someone from his fantastic team, you could either reach out to these details or come and see us, and then they're right next door. So 2 birds, 1 stone. This is our contact details. If there's any questions for us, I'm sorry, we did slightly go over our time. We were worried we wouldn't get to the 45 minutes, but who knew lawyers and accountants love talking so much? Any questions in the audience? No, we've covered everything so well. So there's, oh, there's a good one. Yeah. Oh yeah, yeah, yeah.
It just seems so smooth. It didn't say, you know, the usual.
Yeah.
The 2 sides.
I'll tell you a better case in a moment. But I'll just finish up the webinar so that people here can leave, and then if everyone wants to sit around for the last, it's a really good case. But that's a great question, David. So there's no questions online, so I'm going to let everybody online go and get back to work or enjoy their lunch, whatever they're doing. So here are our details. Thank you for joining. Please join us for our next webinars, which we don't really have just scheduled just yet, but you'll hear from us. Thank you for joining. If you've got any questions, here are our details, and have a great day.